All right, I hope everyone is enjoying your breakfast, but we should get started. For those of you, maybe I don't know, I'm Fritz Mayer, Dean here at the Korbel School, and I'm just kicking the event off. This is one of a series of Scrivner Policy Roundtables, this time in partnership with the Center for Immigration Policy and Research here, CIPR, at the University of Denver. These sessions we're really proud of them. And I think increasingly important in this moment where, how do we say this? There's perhaps less attention to evidence, data than we've ever seen, at least at the federal level. And so important in general that we have these conversations about what it means to have evidence-based, thoughtful conversations about policy issues. And probably no issue suffers more from less of that at this moment than issues around immigration, immigrant rights, migration generally. I don't need to tell you, because you're here, you know of the importance of this, and it is most unfortunately become such a hot button political issue, so much frankly demagoguery around the issue, so much well, at this point, extrajudicial behavior, so many concerns for all of us in the community. I know Naz as an immigrant herself, myself as the son of an immigrant, all of you who have proximity, are yourselves immigrants or have proximity. It's very personal for a lot of us, and it feels really personal. All the more reason to keep fighting the fight, to have sensible, thoughtful, informed discussions about this set of issues. So really proud that we're having this event today, and thank you all for joining. I know it'll be a really stimulating conversation as these all are. Let me thank Naz Barma, Katie Aker for these events. Naz and Katie do a fabulous job with our Scrivner Institute, and Rebecca and Lisa, thank you so much for being here with CIPR today. So with that, let me pass the mic to Naz, and welcome.
Good morning, everyone, and thanks so much, Fritz, for your support of the work that we do, and that great introduction. I mean, we didn't trade notes, but I'm going to say a couple of the same things, unsurprisingly. So what I'd like to do, though, as we customarily do at this event, and especially in the context of the conversation that we're having today about belonging and identity, I'd like to start with a land acknowledgement. Let me begin by acknowledging that the University of Denver campus sits on the unceded ancestral homeland of the Cheyenne and Arapaho people, who have stewarded this land for generations, and we recognize and mourn their loss, as well as that of all the indigenous tribes and nations who call Colorado and the Rocky Mountain West home. As Fred said, I'm the director of the Scrivner Institute of Public Policy and Scrivner Professor of Public Policy here. Unfortunately, we're not joined today by Doug Scrivner, who, along with his wife Mary, endowed the Scrivner Institute and make this work possible. So thanks to them in absentia. This is the 8th installment of the Scrivner Policy Roundtable. We're in our 4th year of programming. And as Fred said, one of our real goals is to facilitate and kind of provide a platform for a convening space for evidence-based policy conversations. So we're excited to welcome today's presenters, who I'll introduce in just a minute, and really wonderful to see students, faculty, and staff here from across the University of Denver working on public policy issues, as well as our partners in the policy sphere. Our core mandate at the Scrivner Institute is to serve as a hub for collaborative and interdisciplinary policy dialogue. This roundtable foregrounds those issues by really focusing, foregrounds local policy issues by focusing on informed and evidenced dialogue. And today's presentation and conversation by the DU Center for Immigration Policy and Research, or CIPR, fits our objectives perfectly in this current political moment. They will discuss findings from the DU Courtwatch Project, explaining Denver's non-detained immigration court and focusing on two of its core expedited mechanisms. And for lay people like me, they've provided a fantastic cheat sheet on each of the tables of some of the acronyms and concepts that they will be describing. Thank you so much for being here with us and for all the preparation that I know you've been doing. This roundtable format is invitation only for a particular reason. It's designed to be conducive to frank and focused conversations about contemporary policy issues, which, as Fritz just said, all too often take place in the context of heightened political rhetoric, inflammatory political rhetoric. Today, we're going to see what an evidence-based approach to the hot button issue of immigration really looks like. We will be recording the presentation portion of the event, and then we'll turn the cameras off and we'll turn to small group discussion at your tables, facilitated by both the panelists as well as some of their colleagues who are here as well. Those conversations will be conducted under closed door rules where you're free to use the information that you receive, but comments should not be attributed to speakers or institutions, just out of respect for having a robust conversation. A huge thank you again to Katie Aker, Scrivner Institute Assistant Director, who is really the organizing force and brains behind this event. So thanks, Katie. And to our student researchers, Katya, and I think Katya's here, and Derek for all of your help. So, enormous thanks to our team of presenters from the Center for Immigration Policy and Research. I'm going to just briefly introduce them, but they have, all of them, incredibly wonderful and interesting bios, which I encourage you to look at. You all received an email with those bios, but I'll just introduce them briefly. Rebecca Galemba is a professor here at the Corbell School, my colleague, and co-director of CIPR. Next to her is Lisa Martinez, who is a professor of sociology here at DU and the co-director of CIPR. Elizabeth Jordan, to Lisa's left, is visiting assistant professor of law and the director of the Immigration Law and Policy Clinic. And Ella Eveslat, I was so focused on pronouncing the last name. Ella Eveslat, I apologize, lead research assistant for the DU Courtwatch Project. So I'll turn it over to you all. Again, really, really grateful to you for being here, and more importantly, for all the really incredibly important work that you're doing in this space. Thank you.
Is that working? Okay. Well, thank you, Naz and Fritz and the Scrivner team, and thanks to others on the CIPR team, Mandy, especially Victoria and Gabriella. Thank you also to my collaborators, but also some of our student research assistants who are going to be help facilitating the tables. So Kelly, you can raise your hand. Hasmeen, you can raise your hand. Kay, you can raise your hand, because clearly, as you'll see, it takes an army to look at the immigration system. And then we have also, who's not here, Jesse Acevedo, helping with some parts of tracking down some data for the project. And we also want to thank Cecil and Prof for funding this work and some of our collaborations with Remain and the Colorado Asylum Center here. All right, let me figure out how to work this thing. Okay. So I'll give a little bit of an overview to the Courtwatch Project. There's actually a website which Ella designed and a tableau of all our observations, which Ella also designed. She also was a winner of last year's Corbell Excellence in Writing Thesis Award for much of this work, so she deserves a lot of credit for that. And so again, we've been doing this project now for since May 2022, and this includes observations in Denver's immigration court, which is right downtown. We observe what are called master calendar hearings, which you have on your cheat sheet, which are early preliminary hearings. Mostly administrative. People in removal proceedings may have a couple of these before their final hearing. They could be stretched out perhaps over years, or they might happen in as little as you'll see on the dedicated docket, all kind of pushed together. What's interesting is that these are open technically. I say technically, they're not always to the public, which provides really interesting opportunities for transparency, as well as seeing why, and you'll see throughout our presentation, so many people never make it to the final part of this kind of final hearing. And so there's data that shows that 91% of asylum final decisions actually had attorneys, but that's people who got that far. And we'll show you what happens of why people do not get that far and why that statistic's a little misleading for how our immigration system and asylum claims actually work. We also have interviewed a bunch of attorneys and advocates, including many around the country, about a program called FERM, which we'll also talk about. We've also been volunteering and taking notes in asylum clinics, and Hasmin has really taken lead on that, where you can really learn how difficult it is to fill out these applications, even if you speak fluent English and have a PhD. I think I used like a whole bottle of whiteout. Again, we've had many students work on this, including in my class as well. The collaborations as well as that you see here. Okay, so just a few things I think that we want you to take away. Above we kind of our research questions, but we're gonna get you less into the nitty gritty and more about like, why do we care about this today? And again, most of our research occurred before the change in administration, but we can learn a lot about what we see being facilitated now by what was already happening in the immigration system. So our focus is on how these kind of faster immigration dockets have impacted due process and access to justice. They're often billed as like, there's this really long backlog in immigration court and things take too long and it's super inefficient. It's like, why don't we just give people like a faster track? And we'll talk about why just speeding that up has actually made things worse and less efficient. But again, we want you to take away the big takeaways that immigration court is not like normal court. That's something that you will learn, and what some of law students who take my class find out. They're the most surprised about that. Again, the merits of asylum claims are still strong, right? We often hear about this term like unlawful asylum seekers, which is actually an oxymoron, which we can talk about, or frivolous claims or ineligible claims. But in fact, most asylum claims are still strong if people actually have the chance to make them fairly, which is what we're gonna show you is the issue. And again, this is also reinforced by why we think this, again, that there's a problem, right, of frivolous asylum seekers by these narratives that delegitimize asylum seekers. And this has been especially so at the southern border for countries from Latin America, which have had historically low rates of asylum grants despite the merits of those claims. Okay, and then I'll turn it over.
Thanks, Rebecca. I'm going to provide a little bit of context, and we're going to sort of go a little bit back into time to help set up what's going to be the main part of our talk today, and how we got to the point of thinking about these asylum processes and got to the point where we are today. So we start with an image of the St. Louis, which was a German liner. This is from 1939. And essentially the passengers that you see on board there were people who were fleeing Germany due to the events of World War II. So this ship set sail for Cuba in hopes of getting reprieve. They were denied and turned away. The passengers on board hoped that they would have another opportunity, and so they appealed to the US government, who also turned them away. Many of these individuals, of course, were forced to flee from Germany. Some were eventually able to make it to the United States, but others, of course, perished in the Holocaust. Oh, I have the thing. Multitasking. Okay. So as a consequence, from the devastation of World War II and, of course, the neglect of the people who were trying to flee those events, the international community, including the United States, decided and realized that it was important to develop an international framework for how to address those who were fleeing from persecution. So this led to the creation of the United Nations in 1945, and in 1948 to the creation of the Universal Declaration of Human Rights. Part of the declaration was Article 14, which establishes a basic human right, which we still affirm today. Everyone has the right to seek and to enjoy in other countries asylum from persecution. This also included the idea of non-refoulement, which is a fundamental principle of international law forbidding the deportation of a refugee or asylum seeker to a country where they are likely to face persecution. Now, here it's important to mention that with these developments, we also see sort of a distinction between people who are seeking refuge or refugees and people seeking asylum. And that's an important distinction because people who are seeking refuge are essentially seeking it from another country before they arrive to the country of resettlement, versus asylum seekers who are seeking protection once they show up in the country of destination. They've already arrived or they've presented themselves at a port of entry. So these developments further led to the creation of a new resettlement system, and essentially it resulted in a combination of things. The first and perhaps most importantly is it led to the creation of the United Nations High Commissioner for Refugees, and it also led to protocols as well as in 1980 passage of the Refugee Act, which was really key because that's what formalized the U.S. refugee settlement infrastructure. Today, and what we'll be talking about, is really about how the process for refugee and asylum seekers is quite different. So essentially, these developments sort of set the stage for where we are today, such that, for example, in the last couple of decades, with each administration, sort of the bars or the requirements for what is required for people to actually be granted asylum have essentially been raised. So starting with Clinton, all the way to the present, you see that bar increasingly gets raised for folks. So that's just a little bit of background to help contextualize the things that we're going to be talking about today.
Hi. Okay, so I'm going to really focus in on the first takeaway we want you to leave with, which is that immigration court is a very unique and troubling court system here in the United States. Immigration court exists to process people for removal. So what that means is the United States government has a system to deport non-citizens, and immigration judges are tasked with kind of two decisions. The first is the person actually deportable? Or removable, and the second is, if they are, do they have a claim for relief? Can they stay in the United States anyways? The judges making these decisions are employees of an agency called EOIR, the Executive Office of Immigration Review, which is an administrative agency housed within the Department of Justice, which means that their boss is the Attorney General. And that means that their boss changes every 4 years, or less, depending on how quickly an administration churns through attorneys general. These are not independent judges, adjudicators, with the kind of protections of independence that we see in other court systems. For example, federal judges have lifetime tenure. Immigration judges have no such protection. And we see that they are really quite vulnerable to pressures by the political kind of leadership of the executive branch. So removal proceedings, there are more than 3 million people being subjected to removal proceedings in the United States today. And like I said, the decision there is whether or not somebody is going to be ordered to leave the United States. Asylum is a defense to removal, and that's really what we are focusing on. But it's important to note that asylum can also be sought affirmatively through a different agency called USCIS, which we will be kind of touching on repeatedly throughout. So this is somebody's removal defense, asylum as a defense to deportation. And again, it's an immigration judge who makes that decision in an adversarial courtroom setting. Most immigration judges are hired out of the Department of Homeland Security, which is the agency charged with removing people. So most of them worked as attorneys for ICE prosecuting deportations prior to becoming judges. I'd say the other major source for immigration judges is the military adjudicative system. There are lots and lots and lots of studies out there about how much the judge you get makes the difference for your case. So an article I will recommend to everybody is one called Refugee Roulette, where it shows how outcome determinative the specific judge is. And if you look, you can look up judges' grant rates. They vary really wildly. You can also look up grant rates by location. We have immigration courts throughout the country, and say, for example, if your case happens to be docketed in San Francisco, you are likely looking at a very different outcome than if your case is in Dallas. The other kind of factors that are really outcome determinative are the presence of counsel. We know that folks who are assisted by a lawyer just by orders of magnitude have a likelier chance of success, but counsel is not guaranteed in immigration court, which I will talk about in just a second. And then the other thing that's really outcome determinative is whether or not the non-citizen is detained while they're going through the removal proceeding. So we have detained dockets, we have a massive incarceration system that ICE runs. It's a civil incarceration system, and whether or not somebody is detained really impacts their removal case, because as you can imagine, it's very hard from detention to gather evidence, contact a lawyer, things like that. Our detention centers are often, as you might have seen in the news, located in places like rural Louisiana. And then, like I said, these are civil administrative proceedings. So for more than 100 years in the United States, deportation has been considered a civil penalty, not a form of punishment. And what that means is that you are not given the rights that you would be given if you were accused of a crime when you are facing deportation. So you do not get the right to a lawyer, provided at government expense. There is no public defender system for immigration court. And because deportation is not punishment, you can't also challenge it as cruel and unusual. You're kind of stuck within the administrative law of immigration court only. I think it's important just to note quickly, as I mentioned, non-citizens can be detained throughout their removal proceeding. We have a 1,300 person private detention center in Aurora that houses people picked up by ICE in Colorado, Utah, and Wyoming, and also transferred to ICE custody from the border. So we have thousands of people going through detained removal proceedings here in Colorado every day. And then the other thing I just want to note is that the Department of Homeland Security is now the kind of enforcement arm here. Those of you who are my age might remember when DHS was created. It was a creature of the George W. Bush administration and kind of couched in the terms of national security. So within the Department of Homeland Security, we have ICE, which is the enforcement arm, CBP, which is the enforcement arm specifically at the border or other ports of entry like the airport, and then USCIS, that administrative agency I mentioned earlier that processes more benefits, things like employment-based visas, and also affirmative asylum applications. This is a little flowchart to try to help explain the immigration adjudicative system. As I said, these are administrative proceedings, and so immigration courts are housed within EOIR, that agency that lives in DOJ. There is also an appellate body within DOJ called the Board of Immigration Appeals. So if you lose at immigration court, your first stop on appeal is the Board of Immigration Appeals, which is also staffed by people appointed by the Attorney General, and administrative proceedings. A weird quirk, not really relevant here, but one I like to share anyways, is that the Department of Homeland Security can actually also appeal. So if you win your asylum claim, you can still lose on appeal. So unlike in criminal court, where if you beat your charge in criminal court, you're done. In immigration court, if you win, you can still get it reversed on appeal. There is a federal court review process for immigration decisions, removal decisions specifically. It's also a bit of a strange procedural vehicle, unlike other areas of the law. The first place you go after you lose at the Board of Immigration Appeals is the Court of Appeals. So you don't go to the District of Colorado, you go straight to the 10th Circuit through something called a petition for review. The immigration law has some very strict standards about what those federal judges can and cannot review. The review is very deferential by law, so the federal judges don't get to kind of step in as independent adjudicators. They have to offer a lot of deference to the immigration judge and to the Board of Immigration Appeals, and they can only review certain issues that are raised. They cannot review the entire case. There's a lot of what we call jurisdiction stripping. The other thing to know about the petition for review process is that it does not actually pause somebody's deportation. So somebody may be seeking that last round of appeal after they've been removed from the United States. And as you can imagine, not a lot of people maintain that appeal from abroad. It's very hard to keep track of clients, especially if they're asylum seekers and they've been deported back. They're often in hiding while trying to pursue the appeal. So it's a very difficult process in that way. And as a result, not a lot of people seek that last round of appeals. especially here in Colorado.
Thanks. So again, that sets the context for where we are today. Again, the long immigration court backlog, which we mentioned with, asylum cases, you may not have a decision for 5 years on your case. But after Title 42, some of you may have remembered this policy that was put in as a COVID restriction, despite evidence showing that there was really no health justification for this. It was largely used to expel asylum seekers back across the border, starting in March of 2020. And again, that expired in May of 2023. And Biden faced a lot of pressure of like, what are you going to do out the border? There's going to be like a surge of people. And actually, if you look at the evidence, like one, that was not really actually true. And in fact, Title 42 didn't actually deter migration either. And so a lot of that was actually quite misplaced and exaggerated and panicked. But there's two things that we focus on that Biden did to look at these issues. One was the dedicated docket, which was started in May of 2021, so before that, and that was about, again, putting specifically, these are policies actually targeted at families, okay? And Biden also wanted to, at the time, and now we're hearing it again, avoid both the ethical, moral, logistical, financial, legal hurdles of family detention that occurred during the Obama administration. So it's like, how can I sort of do that but not do that, right? In a way that like nobody sees it, right? How do we get people out of here but not actually have that happen? And we argue many ways that these two policies have a lot of similarity. And so the dedicated docket chose 11 cities, supposedly for their presence of legal resources, which is pretty ridiculous. Actually, Colorado's the lowest representation rate right now in the country. And again, these were supposed to be fast-tracked within 300 days to your final decision. In keeping in mind how people get work authorization in the asylum process is that you actually cannot even apply for your work permit until your application for asylum has been submitted, and then you wait about 150 days. So it's about 180 days total, and that's if things are like working on time. And so if you're talking about that and you have 300 days till you're done, like when do you work and pay for your return? Like how does this happen? And so we're looking at that. And then FERM, this policy here, was implemented alongside a suite of other policies, which we'll talk about later, really on the same day, basically, that Title 42 expired, largely because the infrastructure they had in place for single adults, like they just didn't have the capacity for families to do that. But what's really unusual about this is that it was using an expedited removal process, which basically is when a low-level immigration official can deport you without ever you seeing a judge or having a hearing at all. And the only defense is a credible fear of return. If you express a fear, you're supposed to be referred to an asylum officer for a credible fear screening, and we'll talk about that to access the asylum process. Now under Trump, we're seeing expedited removal expand, and we'll talk about that later. But what's really different than this is that expedited removal usually occurs when immigrants are in detention. This was an experiment to do this like massive experiment of it when people were actually released into what's often called alternatives to detention via electronic surveillance, which we'll talk about. And that happened in 45 cities across the US. And again, it's just to remind you, Colorado actually has 2 immigration courts. We're more focused on the downtown one where people are not in detention. But there's, of course, and Liz has worked a lot with the detention facility owned by the Geo Corporation out in Aurora. So again, some of our approach. We originally approached this project because attorneys were really concerned about the dedicated docket. They're like, we know what we're seeing, but we need more evidence about what's actually happening. And as well as increasing just public awareness in general about how the immigration system works or does not work. And attending early hearings is a really good way to do that, right? Kind of what happens here? Is there some transparency? There's really no accountability when, judges make mistakes, right? Or don't read your rights out to you and don't follow the rules. Or they might follow the rules, but do so in a really, really snarky way, which we'll talk about. And so again, our approach here was to observe these dedicated docket early hearings and compare them to ones not placed on the dedicated docket. And often we found there was like no real rhyme or reason of like, besides certain countries, right, that were targeted, but even within those of like why you'd get placed on one versus the other. Again, this kind of roulette of, and again, with really grave consequences for people's cases. We use standardized forms from an organization called Innovation Law Lab, which enables comparison across the country, although they didn't have anything for dedicated docket. And Ella is largely responsible for making our entire database, which she'll show you in a little bit. But we also coupled this with participant observation, which meant we sit there and we take notes of what's actually happening in the courtroom, because as we mentioned, judges often comply, but the way they do so sends people a message, right, about how they're going to engage with that system in the future and what they actually don't, I would say, understand, but don't understand about the process. As we were doing this, we heard about FERM rolling out, but no one really knew anything about it, which we'll talk about. And so Liz basically said, and maybe people are too young, like, we're gonna have to Aaron Brockovich it. And we're like, what does that mean? It's like, basically, like, we just have to get like a team together and figure out and find what's going on and like try every angle possible to sort of track what's happening with this program and who may know something about it. So even like Liz, I think we have the first case that got referred to interview, and he went through the process, and you asked him, like, you know, about FERM. He goes, what's FERM, right? And this is somebody who's been through the process. How little is known about it. Again, it's really hard to find information. So again, we have all these attorney interviews to understand what happens with cases on a broader spectrum, right? Not just in Denver, but around the country, and how they've experienced these cases versus their regular work and how that's changed. And again, because we can't look at final outcomes with the data that we have, there is a Transnational Records Access Clearinghouse via Syracuse, which you can apply to get raw data from the courts. Lisa will tell you it's a mess. There used to be some codes for the dedicated docket. Now we don't seem to have them, so we're working on them so we can try to actually track this through track to see like how this actually impacts the outcomes, especially of dedicated docket cases. And later I'll talk about why we can't do that actually for FERM. And then we've also been, again, volunteering at clinics, both to help folks out, but also to kind of really get a sense of what it is like to apply through this process. Okay, I'm gonna turn it back to Ella.
Maybe? Yeah, okay. So on the left-hand side, we wanted to give you guys a little bit of an example of what the Innovation Law Lab like data tracking forms look like. So this sample section up on the screen, the whole form is about 4 pages long. But this sample section asks observers whether or not a judge, during an initial rights advisal in immigration court, provided information to respondents about their rights that they have in immigration court, such as, for example, a migrant's right to be represented at their own expense or their appellate rights. And then on the right-hand side is an example of what our free-form participant observation notes look like, and these focus more on qualitative forms of data. And they are handwritten in court because we can't bring any sort of forms of technology in and be using them during court. And then observers then type them up electronically and keep them in like a shared Google Drive where we all have access to them. And these notes include both general observations, as well as the thoughts, emotions, reactions, and questions of observers, which, if you can tell, are italicized within the context of the notes. So then, the picture on the right-hand side is a screenshot of the front page of our Tableau dashboard that we created based on our quantitative observational data. And this is an interactive data dashboard, if you're not familiar with Tableau, and is available on our website, as well as through the QR code on the little handouts on your table, if you're curious to look at that. And as a result of our quantitative analysis, as showcased in the Tableau dashboard, as well as some of our analysis, and much of it is rudimentary, let's keep that in mind because of the track, and as Dr. Galumba explained, the problems with that, 4 primary findings have sort of emerged from that. And firstly, the Denver court has low representation rates. So per our observations, most migrants observed in hearings are unrepresented, or precisely 82.46% of them are unrepresented. And the disparity is greater amongst dedicated docket hearings, where 90.53% are unrepresented. Secondly, there's a notable prevalence of migrants having an incorrect address on file with the court. And this may lead to migrants being removed in absentia, basically just being removed because they're not present in court that day. Having a correct address on file with the court is absolutely essential to make sure a migrant receives up-to-date information on the time, place, and location of their hearings in a mail-based court system. Address errors may occur for a variety of reasons, including a migrant becoming confused by a disconnected and very complex system, case timelines, language barriers, cultural differences, a lack of representation, and errors committed by ICE, Border Patrol, and the immigration court themselves. Thirdly, track data reveals that there is relatively high rates of asylum denial. These vary between immigration judges, and this also reveals a larger pattern of the variety in the discretion and conduct amongst Denver's immigration judges. So the graph on the left-hand side is a visualization of the disparity in asylum grant rates by judge, which comes from our track data, and it is through the time period from 2019 to 2024. The red represents the percent granted asylum, while the gray represents the denial rates. Additionally, the graph on the right-hand side is the perceptions of immigration judge conduct collected by our Courtwatch observers. So the red colors on that right-hand graph reflect observers who evaluated immigration judges to be unfair, unjust, impatient, and unprofessional, while the green is the exact opposite and indicates positive perceptions of immigration judge conduct. However, while these two graphs can begin to illuminate the picture of judicial conduct in the courtroom, it is only through our qualitative participant observations and data that we have really been able to understand the stories behind these quantitative numbers. So, through the qualitative component of the Courtwatch Project, we have been able to gain an even stronger understanding of how immigration law functions on the ground at the Denver Immigration Court. In a context of strained resources and burdensome caseloads, we have observed themes of inconsistency, overcrowding, under-resourced courtrooms, and in general, themes of respondent confusion. Secondly, linking to the graphs on the previous slide, while judges have been observed to be relatively compliant with legal procedures and guidance, the way in which they do so is just as important. For example, their tones and body language illustrate important nonverbal cues. Moreover, the depth of rights advisals, the words that judges use, and even sometimes the jokes that judges make can change a respondent's ability to understand the complicated immigration process. Likewise, observers noted instances of interpretation and technical problems in court as well. While the vast majority of respondents do speak Spanish, finding interpreters for less commonly spoken languages, like indigenous languages, can be difficult and may lead to other errors. For example, if a judge is unable to find a proper interpreter, they are supposed to continue the case to find an adequate interpreter for that respondent, but they still might choose to verify a respondent's address in a language that the respondent doesn't even speak, so that the respondent can receive a notice to appear for their next hearing. Likewise, limited court resources and an aging technological infrastructure can add additional barriers to a routine court process. For example, problems as simple as a court printer not working or a lack of court clerks may mean the respondents in that docket do not receive copies of essential forms and documents. Even the general setup of the Denver court adds barriers to accessibility. Finding street parking can be a nightmare, and the nearest parking garage is expensive and difficult to navigate. There's not even signs at the entrance indicating that it is the correct location of immigration court. Accessing court can be even more difficult for those without access to reliable transportation. And in some cases, we've seen respondents share that they've walked over 6 hours just to get to court. Moreover, migrants may even arrive at the wrong date or time, often through no fault of their own. Judges have often noted to us that it is not uncommon for the court to continuously reschedule the time and date of hearings, and it can be overwhelming to keep up with all of these changes. Another prominent finding out of the qualitative data, which kind of goes hand in hand with the implications of address errors that we uncovered in the quantitative data, is the issue of miscommunication between DHS, ICE, and the court, as well as filing and clerical errors committed by ICE. If ICE fails to file a correct notice to appear with the date, time, and location of a hearing, or completely fails to file one at all, for one or more members of the family unit, they might not be put into proceedings. Even things as simple as a misspelling of a name or an address on one of these notice to appears can add significant difficulties for respondents. If a respondent misses a hearing, they might be removed in absentia. Even if the judge discretionarily chooses to continue their case, rescheduling hearings due to migrants missing a hearing or showing up at the wrong time further strains court resources. Unfortunately, most of these errors revealed in the qualitative data are only compounded by the fast timelines on the dedicated docket. Under the dedicated docket, the goal is that there is only 300 or fewer days between a migrant's initial master calendar hearing and when an immigration judge issues a final decision in their case. Per a 2022 report, these case completion goals were largely met, and 83% of closed cases were completed within this 300-day timeframe. For comparison, regular non-dedicated master calendar cases can often take years from start to finish. While the dedicated docket has largely met its goal of quickly churning through cases, it has done so at the cost of efficiency and fairness. The dedicated docket program lacks transparency, and many respondents, and sometimes their attorneys, do not know a respondent is assigned to the dedicated docket until their first master calendar hearing. and it is largely unclear how cases are assigned at the border. At large, it appears that assignment is arbitrary and capricious with outcomes that are rather extreme. Moreover, the fast and unpredictable timelines of cases add additional barriers for respondents finding legal representation. Quick turnaround times may make it difficult for a respondent to find pro bono representation or save up for the money necessary to pay for an attorney out of pocket, often at the same time as family units are just finding their bearings. Moreover, attorneys may be hesitant to take on these dedicated docket cases where they have limited time to prepare or where they fear the instability of these unpredictable timelines. At the end of 2022, most dedicated docket cases were closed without a respondent ever finding an attorney, and in Denver, only 39% of dedicated docket cases had representation. Dedicated docket cases also have a relatively low success rate. Per track data from 2022, only 28% of dedicated docket cases were granted asylum, as compared to 52% on the regular docket. But only 7% of the cases closed on the dedicated docket were able to win an asylum claim because it is so incredibly difficult for respondents to file an asylum application and make it to the final hearing without attorney help on a dedicated docket timeline. Finally, the dedicated docket is extremely inefficient. The system at large is error-prone. For example, in the most recent dedicated docket I observed in February, I observed a total of 15 cases, and 1/3 of these cases had some sort of issue with a missing or incorrect notice to appear for at least one family member on the case. In another observation back from October 2023, Dr. Galemba and I sat through a dedicated docket under Judge Koppenhofer. The judge noticed that the woman's case, but not that of her young child, was set on the docket for that day. The judge soon realized that ICE had failed to file a proper NTA for the child, even though the mother had one herself. Judge Koppenhofer discretionally decided to remove the family off the dedicated docket to give them more time. The judge remarked to us after the trial that, and I quote, "I don't know what is better or worse, being removed quickly to figure out options for being here for 5 to 6 years and then denied after so much time." End quote. Prior to moving the case off the dedicated docket, the respondent and her family would have only had 7 months to complete their entire case. However, after being moved off the dedicated docket, the family now had 8 months before only their second hearing out of what is typically 3 or 4 total hearings. Compared to the regular, non-dedicated dockets, which can take a few years to complete, families in dedicated docket hearings receive only 300 days. This extra time on regular dockets can make a massive difference in respondents' ability to gain work authorization, find an attorney, collect evidence, and file an asylum application in English, and even just finding their groundings in a culture and country that is far different from their own and often very unwelcoming. The court is ill-equipped to handle this amount of cases, and this is only burdened by the fast timeline of cases. Speeding up a bad process only makes it messier. With the prevalence of errors we have observed in each docket, the question then is raised: when so many people are going through court at such a fast pace, what errors aren't getting caught? It's like assembling IKEA furniture on fast forward. Quicker to build, but you'll definitely end up with extra screws and a wobbly shelf, even though it's questionable if it's even going to be stable in the first place. The expedited nature of the dedicated docket amplifies the many problems and inadequacies already present in immigration court, whether it be ICE's failure to file proper paperwork, inadequate access to court translators, especially for Indigenous languages, incorrect addresses on file with the court, or even as simple as general confusion amongst respondents who often do not have adequate access to representation or attorney help.
Great, so that is the dedicated docket within the immigration court. We're going to turn now to a different program going super fast called FERM, the Family Expedited Removal Management Program. So again, like Rebecca said, FERM was rolled out by the Biden administration roughly on the same day that Title 42 ended, right? So political leaders felt like Title 42 was keeping people out, and they worried about a surge of people coming across the border the day that Title 42 ended, and FERM was set up to kind of catch those family units in particular. Expedited removal is a process that 85% of folks coming across the border are subjected to, It is a summary removal process. It means that people do not even get to see an immigration judge and experience all of the chaos that Ella just described. Rather, a CBP agent at the border, so somebody not a lawyer, not an adjudicator, just removes people. We can thank Bill Clinton for the expedited removal process. But the way to avoid that summary removal is to express a fear of return. And so if an asylum seeker is subjected to expedited removal but says, you cannot send me back, they're going to kill me, or whatever it is that they're afraid of, then they are taken out of expedited removal and run through a series of kind of screening steps and then potentially access the immigration court. So the Family Expedited Removal Program was set up to process family units seeking asylum who are subject to that expedited removal process. Prior kind of versions of programming to stop asylum-seeking families include the family detention system. So folks might recall we had a number of facilities, mostly across Texas and New Mexico, where whole families were detained by ICE. Some folks called those baby jails. We think that they are coming back under this Trump administration, but they were closed down for a while because it is, kind of deeply problematic to put asylum-seeking families into a jail. So instead of physical jail, the Family Expedited Removal Program put folks in a digital jail. So family units were processed. The goal of the program in the kind of white box here is to impose immigration consequences in a safe and humane way for those who fail to use available pathways and removing families deemed to be ineligible for relief. So from the start, the objective of the program is to kick those families back out, right? This language is premised around the fact that they're not going to be successful. So families who are put in the FERM program are subjected to expedited removal, but they're not detained and they're not kept at the border. Rather, they are released and sent to cities across the country where they can be within 75 miles of the kind of ICE surveillance mechanisms that exist under the rubric of alternatives to detention. So literally what would happen is like the father would get an ankle monitor and they would go on to wherever they were going, including here in Denver, and then they would have monitoring requirements with a company called BI, which is a private company also owned by the GEO Group, who ICE has outsourced their kind of community-based surveillance. So just to explain using maybe an example, a family comes to the border, they say, we're here to seek asylum. The Border Patrol agent processes them, says, where are you going? And the family might say, oh, I have a cousin in Denver. And they say, great, you're going to Denver. We're going to put you in FERM because FERM exists in Denver, this program here. We're going to put the head of household on surveillance mechanisms. And then we're going to put you through a very fast process in Denver. So, as I mentioned, the way to get out of expedited removal is to express a fear. And the first step is a fear screening called a credible fear interview that USCIS conducts. So this is before anybody ever sees an immigration judge. FERM required that fear screening to be conducted very quickly, and Rebecca's going to talk us through that a little bit more. As you also saw in the language that I just read from, the Biden administration also had a strategy of trying to funnel asylum seekers into certain mechanisms for accessing the border and seeking asylum. So if folks did not, quote unquote, come the right way, then they would be subject to extra penalties. And the FERM program felt to us like one of those penalties, but there were several other penalties out there. As I said, a lot of expedited removal kind of happens in the context of detention close to the border. FERM feels like an experiment of subjecting folks to expedited removal, but it's outside of the scope of detention or the context of detention. And what that has created, as we'll talk through, is this kind of under-the-radar mechanism where instead of having these families concentrated in one place, they are now spread out throughout the country, trying to find an apartment. Dad has to check in with this private company surveilling him, and then they go through this program very, very quickly. So I think Rebecca's going to give us a timeline.
just said they were also held to these higher standards. And the only lawful pathway that was basically put in with very limited exceptions was using this app called CBP1, which you may have heard about. So this kind of gives you a graph of what happened and the decisions that go into FERM, and we'll talk about how it's both very targeted but also very arbitrary at the same time. And what, picking up on what Liz said, is that something is geared towards presuming people are ineligible when it's targeting populations that already have historically low rates, right, of being granted asylum, as well as the fact that you couldn't find actually graphs of well, what happens if they're positive determinations? All the graphs are tiered towards ending in that box, which is removal in 30 days, right? This idea is supposed to that you come in the country, present yourself to CBP asking for protection, and you're removed within 30 days. It's hard to find in the time well, what happens if your fear screening is positive, which is really ironic if you look at credible fear screening rates nationally, even since expedited removal, have always been pretty high. Whether people win their case is different, but the actual rate of passing screenings historically has been pretty high. So I'm actually going to walk you through an example that Kelly, who's in the room, helped document with another one of our policy students who graduated last year, Fatima. And I think this shows, again, of this whole Erin Brockovich thing, how do we find people in this? Attorneys didn't even know it started. The only reason they realized it started in Denver, and these are the ones who would have been in charge of helping people in this, was because they happened to be at court that day and saw someone having what's called their negative credible fear review, which I'll talk about, which is the last stop before you end up in that box at Denver Immigration Court. She's well, that's weird, and we'll talk about why it's weird. This must be a FERM case, right? That's how she ended up finding this in the first place. So I'm gonna give you a case study about this woman named Mariana, which was the first case that Kelly and Fatima were able to accompany to court. So I'll walk you through the process. I don't know if there's a pointer here, but so when she and her daughter, for example, they entered without inspection because that was the only way, actually, to access the border, which we'll talk about, which is called EWI. And at that point, the officer actually has a decision to make. You don't have to put someone into FERM. You can just release them with a notice to appear. And historically, asylum seekers show up for their hearings because they want to get asylum. And so we'll talk about that. So you had two choices because she met the criteria. Okay, so would he put her in FERM, which is box number 2, and send her through this kind of tilt-a-whirl, which we'll see over here, or would he just put her into proceedings, maybe assigned to the dedicated docket kind of roulette that Ella talked about, or in the regular docket, right? That would be another option, okay? So she met the criteria even though they're vague. So the criteria are, is it a family unit, okay? That just means one or more parents and one or more children under 18. So yes, Biden wanted to avoid family separation, but in effect that didn't happen because if you come with your 19-year-old, her 19-year-old could have been in the box up there waiting 3 years for proceedings while they're kicked out of the country in 30 days. Similar if they had crossed the border at different times just because of how difficult that is to do. Again, they entered without inspection because they hadn't used CBP1 to make an appointment first. And then she wanted to ask for protection. The other criteria, she was from a country which the U.S. can deport people to, right? There's a deportation agreement, and there's what's called a regular cadence of removal flights, meaning you can get them on a plane very fast. Nothing says this has to be countries in Latin America, and nothing says these people have to be Spanish-speaking. Every case we encountered has been from a quote-unquote presumed Spanish-speaking Latin American country, which means attorneys were shocked to see indigenous language speakers in this program, and they are, okay? Again, that's exclusively who we've seen, and they were going to Denver, right, which is one of those 45 FERM cities, and it was within 75 miles of the BI office, which she just talked about, for their check-in, which meant that the GPS monitor would work, okay? And she didn't have any medical conditions that would preclude wearing that ankle monitor. And again, BI is not really an alternative because, again, it's owned by GEO. And again, this whole idea that she was almost presumed ineligible, just not by using this CBP1 app, but again, maybe she'd never heard of it. Maybe she couldn't access it. There were a lot of problems. The wait time to book a CBP1 appointment in Mexico was 6 to 8 months. Anyone who went to Jason de Leon's talk last night knows the gauntlet of traveling through Mexico. All it does for most people stuck there is make them have to flee for their lives once again, right? They're already fleeing. They're going to be fleeing again from the violence in Mexico. The decision, again, would depend on the officer. The border crossing, was he busy? What kind of mood was he in? One attorney said, were there any ankle monitors available, right? That could make that decision so arbitrary within being very targeted towards families from Latin America. It's unclear at what point she gets any legal resources or information at all. And then she gets placed in a FERM and this clock starts ticking over there, okay? And so again, this all happens in a matter of days. And so they'd have to find their own way to Denver. Nobody's paying for that. They have to know where Denver is. They have to find a place to live. They have to find food, get any medical attention from the journey, maybe enroll her kid in school. But this has to be really quick because within days 1 through 5, they have to check in with BI. And that's not 1 to 5 days from arriving to Denver. That's 1 to 5 days from when they get out of CBP custody at the border, right? This happens really, really fast. They may give her some legal resources there. That's what we've heard, where maybe they're accurate, maybe they're not. They put her on an ankle monitor. These are not only humiliating and painful, but sometimes they even beep in the middle of the night. This is not surprising because BI used to use this technology to monitor cattle. That's what they did before. She's also under a curfew. She also gets a SmartLink phone to upload a daily selfie as if that's not enough that she has to do, but it's not a real phone because she can't make any calls or receive any calls on them. This is, again, despite the fact that people show up for their hearings. Okay, within a few more days, you see days 6 through 12, she'll have that asylum interview at an asylum office to assess her credible fear. Okay, this is not asylum, it's eligibility to even enter the process above. So the USCIS office she has this interview in is in Centennial. But Centennial is a pretty small office. It's under the jurisdiction of Houston. And we found out they don't actually do asylum interviews. They don't never do them. Someone from Houston usually comes to do those. So what they do is they give her a speakerphone to talk with a USCIS officer who's in Houston. So she has to tell her whole story to a stranger she can't see, okay? She doesn't understand what qualifies for asylum. She just knows if she goes back to Colombia that the ELN guerrilla group is trying to kill her. Her daughter is next to her while she's on the phone. She also has to come to the interview. She doesn't technically have to be in the room while her mother's doing this, but she has no one to watch her in the waiting room, and she's not allowed to be unattended. She doesn't know anyone. She tells the asylum officer that the ELN was extorting and threatening her. They even killed her brother as he stepped in to shield her, but that wasn't enough to qualify for asylum. She was denied. Then you see this next phase right here. Again, you do have the chance for one more chance. You could be removed, or you can ask for a negative credible fear review or an NCFR. And that's with an immigration judge in Denver, okay? And we'll talk about all this kind of moving around. Okay, the Centennial office is supposed to actually process her paperwork and give her a copy of that transcript so she can actually use that in her review with the judge. But sometimes they don't do that because they've never done this before. And we've seen judges saying, what's going on here? And then they send the whole case back to Houston anyway. Again, the Biden administration at the time rightly realized it needed more asylum officers, so it ramped up hiring, but they got minimal legal training and not any training in trauma-informed interviewing. Even if when she gets this transcript, it's in English. And again, the hearing is in 1 to 2 days, right? She would have no time to find an attorney if the one that we are accompanying had not found her first and had been referred by another organization. Another problem is I said, sure, at least judges might know what they're doing. That's not true. Okay, so as Liz mentioned, these hearings, these negative credible fear reviews, normally happen in detention, okay? These are going for in Denver court, which is a non-detained setting, meaning that if the judge has not worked on the detained docket, they don't know what they're looking at, and no one has given them any guidance. Again, luckily, the attorney found Mariana before she went in with the judge to convince her to ask for a continuance, right? Give her a little bit more time so she can maybe try to help her in a matter of days. She got this, but it was only for 5 days, but when you look at the day of the week, it was actually only 2 because it included a Saturday and a Sunday. Then again, the attorney had to drop everything just to be able to prep her. And this is prep, this isn't even full representation. And that often takes hours. She learned that Mariana had left out really important details that would have made a much stronger asylum claim. For example, she had a well-founded fear of persecution based on sexual orientation. She'd been in a relationship with a female ELN member, although she didn't know that she was an ELN member, who when they found out, took her partner and made threats to, quote, make her a real woman. She didn't know, obviously, that this would be stronger grounds for asylum, but it was mostly because her daughter had been sitting right next to her. And when she talked to the officer, she didn't want her daughter to overhear this. She didn't know about the relationship, her mother's sexual orientation, or the threats of rape that she faced, and she definitely wasn't ready to have her hear that. At least with the continuance, though, the attorney could help encourage her to tell the full story, and have someone sit outside the room with her daughter while she could actually talk to the judge more privately. But at first, Mariana was like, nope, I don't want the continuance. Like, I just want to go forward. She was exhausted. She just wanted it to be over. But after the attorney prepped her and she agreed, the decision was overturned. And so she did, her credible fear was warranted. Otherwise, she would have been removed within another week, would be about the timeline, sent on a flight back to Colombia. How much time is it? Okay. And again, the important thing is that she still hasn't won anything. Many people misinterpret that you win that, you have asylum. All it gets to do is put you in that box up there. So again, this idea that she might have to tell her story 3 times over the course of this process. Can I go to the next one real quick? Okay. So just a few things, again, that FERM reveals from this. Again, there was a total lack of transparency, so people don't know, we don't know at what stage necessarily people are getting legal info. Sometimes they're getting into the border, sometimes they're getting into the BI office. Some attorneys are now getting advance notice because they have a good relationship with the court, like happens in Denver. That doesn't happen everywhere, right? Total lack of transparency. Again, a detention standard center of system of access to justice, but you don't know where anybody is. Again, we could FOIA this information, but we would have to actually get it from 4 different government agencies that don't actually track this in between them. So again, it's really hard to even find the information. It's again occurring across multiple cities. It wears people down and rushes them. So again, you see these multiple appointments she had, and like Denver to Centennial, maybe that's not so bad, but the radius of when you can be into FERM, the 75 miles, only takes into account the BI office. It doesn't care how far the asylum office or immigration court. So there's cases like if you live in like Danbury, Connecticut, like 75 miles, you can go to the BI office in Hartford, but your immigration court is in Boston, which might cost you $150 each way in a cab. And so if you're Mariana and you're like, oh, let's continue your case for 3 days, she's like, no, thank you, right? Same thing if you're an indigenous language speaker. So, oh, you can continue this for an interpreter, right? People are exhausted, worn down. If they even know the differences between any of these agencies at all and what's, like, for example, you're not allowed to bring your kids to ICE, but you have to bring them to the CFI, right? Who knows that? Again, it's not efficient because the only thing that's efficient is that it's designed for removal. Otherwise, again, the interview may happen 3 different times. You're duplicating resources between the court and USCIS, and again, doing everything kind of multiple times. Also, they were working with local asylum offices who had no experience, so it might have to go back to Houston anyway. And then again, even the immigration judges, often given these cases, had very little experience with them. And so there's really, again, no meaningful access to counsel. And even when attorneys try to find them, they often don't even answer the phone or don't have reliable phone numbers. Okay. So again, what this really does is winnow down these claims and deems them ineligible to start rather than giving consequences to ineligible claims. And we actually were able to get some data from the Houston office through an attorney. They told them they didn't know representation rates. They didn't give them that information, but they told them what percentage in the field office had passed versus not passed the credible fear screenings in the fiscal year of 2024. And this, again, covers a few different offices, is 33%, which is really low considering that historically at least 3/4, sometimes 90% of people actually pass those initial stages of fear screenings. But to these attorneys, and again, the people who are most equipped to deal with this had actually worked in family detention in 2014. Like, all of this looks really like something we've seen before, and that's the rates that were happening in those family detention centers before attorneys actually mobilized and got involved and basically turned that around overnight. I mean, some attorneys told me then like people are getting declined like 0.5% of the time once they actually mobilized. And again, no one is saying they want people to be detained. Like, that is very, very clear. But they're like, well, at least once we got in, we saw multiple cases at once. We had an advocacy strategy. There were patterns. We had a template. Like, every case kind of looks similar. FERM is like, nobody knows where anybody is or what's going on. It's impossible to aggregate, and even sometimes talking to colleagues in different cities is the only way that people are piecing this together. So it's really hard to mobilize at scale. And the other really concerning thing is like you can churn people through it a lot more quickly because there's no space limitation. And even when people have asked for like what are the numbers enrolled in FERM, like they basically get guesstimates from the government and no real official numbers. And Ken, maybe I'll turn it over to Lisa now, but one thing that we saw at the end, which I think is where we can get to today of like how this sets us up, where gives us this idea that like asylum claims like aren't credible, right? That we're pushing out claims to save the system and make it more efficient, is we know what happened when Trump took office, right? He declared CBP-1 illegal and turned it into a self-deportation tool, right? So he took out any mechanisms. But before that even happened, we were actually seeing fewer people enrolled in FERM, saying what's going on? And Biden had a new order, which basically was detaining families again in CBP custody at the border, often for longer than they were supposed to be, taking off the ability to, you're supposed to ask someone if they have a credible fear of return. That changed. They weren't asking that anymore. You'd have to shout your fear, and the responses we got was CBP would often respond to that. Also, attorneys weren't allowed in. They would respond saying, like, there's no more asylum anymore, the border is closed, right? And so that's really paving the way for now what we're seeing today.
All right, thank you. For the sake of time, and because we want to have discussion and also Q&A, I'll go through these points very quickly. But sort of taking a step back, there are a lot of important implications in terms of what we found from the dedicated docket and from FERM cases. One, of course, Rebecca has already mentioned that because of this fast and accelerated timeline, essentially families are being quickly and quietly removed. And this is an issue in terms of thinking about due process and asylum law, right? You're sort of shortcutting this usually longer process for folks, which has all kinds of implications for people's ability to win their cases and stay in the United States. Rebecca mentioned the point about the presumption that families are ineligible for asylum. Essentially, what results is that vulnerable people are sent back to countries where they're trying to flee from in the first place. So think back to the people on the St. Louis, folks like Mariana. They had real fears about returning to their home countries. There's also, of course, the ways in which these processes reinforce myths about asylum seekers as doing so unlawfully. Of course, you know, the notion that they're making bogus claims, it ties into sort of media narratives and public perceptions about surges at the border and so forth. And then, of course, I think importantly for our purposes today, and especially in light of what we see currently going on, is that these developments pave the way for further restrictions in access to asylum, essentially setting precedents about who can and cannot be let in and who can and cannot be allowed to stay. And of course, given that we are in the second iteration of the Trump administration, we expect to see expansion of expedited removal, and much of it, again, as we're seeing now, being done in a manner without regard for asylum and immigration laws, which is to say, being done without due process. So with that, we have come up with a series of questions, and they're also represented on little sheets of paper at your tables. The first is kind of talking to this question of doing, trying to dispel myths about doing it the right way. That is to say, seeking asylum or seeking relief the right way versus or having your day in court. There's a question about representation and why that's so key, why having access to an attorney is so important in this process. But it's also circular. Most people will never file a successful asylum application, even those who might have, those who have representation have a much better chance, but it's much difficult when people do it on their own. And then the third point, immigration is already a limited due process zone. It's like trying death penalty cases in traffic court, but traffic court may have more due process than what we're seeing and what we have seen. So these are kind of broader Courtwatch lessons that we want to sort of leave you with before we get to the discussion questions, which are on your table. Sorry about that.
And while Rebecca tees those up, yeah, just on the last point, immigration is already a limited due process zone. You know, I think those of you who have been reading the news lately might have seen some other examples of that, right? So I just want to flag those here because they're relevant for some of the questions we want you all to talk about. The examples that I can think of are what happened to Kilmar Abrego, right? The idea that he should have been given more process before being sent back to El Salvador. The Venezuelans subjected to the Alien Enemies Act. Most of those folks actually still have open immigration matters in immigration court. So kind of sidestepping the process they were supposed to be offered in immigration court and disappeared with no process. And then the third one, for this community, especially particularly relevant, is the kind of silent stripping of status for international students. I think we're up to something like 1,400 students across the country who have had their status stripped, some of which has been done without ever telling them. So those are just some examples in the news that reinforce our idea that this is an area where process is quite limited under the best of circumstances, and right now we are not in the best of circumstances. So with that, I think we'll turn it to the questions.
Everyone now to get a little bit more coffee and food, come back to your tables where one of the CIPR team and the rest of the team in the room is going to join you to discuss these questions. And like Rebecca was just saying, you pick at your table what questions you would like to discuss. Let's kind of plan for a discussion for about 20 minutes. So that'll take us to just about 11:40, and then we'll bring the panel back up, if that's okay with you all, to answer kind of any remaining questions, and I'm sure there will be some. But first, please also join me in thanking our panelists for just an incredibly informative and equally horrifying presentation. Really, thank you so much. Okay, look forward to conversations. Thank you.